everyone. Welcome to Wine and Chill. We are drinking red wine today. Look at that. This is Free Gamay, I don't know how to say it, by Maison Noir. I ordered, if you're following me on Instagram, there's also plane flying over, so so many things are going on. Hopefully y'all can't hear the plane. But if you're following me on Instagram, you know for the rest of the year, we are drinking various assortment of Maison Noir because they had a great sale. Also, it tastes great and it's black-owned wine. So usually I drink white wine, but I'm trying about 6 white wines and 1 red wine. So that's where we're at. That's where we're at for the rest of the year. Hey, Candron. Hey, Marcia. Hey, Justin. All right. So we're going to see how this works because my hair is quite large today, but I want to lean in, but I don't want to cut off the hair. So we'll see. So today, just hop right into it. We are going to talk about one Mr. Kanye West again, but specifically just the legal issues. We're not going to talk about his foolery, his, internalized anti-Blackness, his anti-Semitism, his misogyny, his nonsensicalness. We're specifically going to talk about the legalese today because I know we're all tired of him and tired of getting our blood pressure raised. So I thought we would do something a little bit different, which we are going to go through, I would say, well-educated assessments of his potential contract with Adidas, how it was broken. So if you're new to the channel, I'm a recovering lawyer. I used to work in entertainment, and then I worked in tech for about 6-ish years. And the video that pivoted the whole channel to do entertainment law, pop culture, etc., was discussing of 104 pages of Kanye's contracts when he tweeted that out 2 years ago. So we are going to discuss his Adidas contract. Also, I have realized, which shame on me for not realizing this earlier, you can set the setting to only subscribers to comment. So there should be less foolery today. So I'm just going to set it this way, which is going to be great. So this is going to be fun. And hopefully, if you are still in your process of breaking up with a one Mr. West, I wish you a speedy recovery to clearly nix that man quite quickly. So let's start with Adidas and their statement, and then we'll get into his contract. Okay, cool. Well, actually, you know what? Because y'all know I'm going to have to lean in. I can't see. So I'm going to remove me, and I'm going to go ahead and read this. So this is from Deutschland, from Germany themselves. Adidas does not tolerate anti-Semitism and any other sort of hate speech. They should have also said anti-Blackness, but it's fine. Ye's recent comments and actions have been unacceptable, hateful, and dangerous. And they violate the company's values of diversity, inclusion, mutual respect, and fairness. After a thorough review, the company has taken the decision to terminate the partnership with Ye. I always say Ye. Child, I go back and forth between either or because I forget. Immediately end production, this part is important, of the Yeezy branded products and stop all payments to Kanye and his companies. Adidas will stop the Adidas Yeezy business with immediate effect. They are no longer doing any production. This is expected to have a short-term negative impact of up to 250 million euros to the company's net income 2022, given the high seasonality of the fourth quarter. It's the holiday season. Everyone is spending their money. Adidas, and they said, just in case you did not know, Adidas is the sole owner of all design rights to existing products as well as previous and new colorways under the partnership. More information will be given as a part of the company's upcoming Q3 earnings and announcement on November 9th, 2022. All right. So there we go. So they stated, listen, we're done with him. We're throwing him away. Also, we own everything. We own all the things. Do not ask us questions. Yet Twitter is a hellscape. So instead, Twitter decided to insert all of the very interesting and very odd questions or statements. Specifically, I received it by inbox from Twitter. Someone saw this and sent it to me, which I very much appreciated that laugh. Dropped from Def Jam equals earned back masters. Interesting. Drop from Adidas spelled wrong equals earned back sneaker rights. Drop from Balenciaga. That one looks like they spelled that one right. Earn back design concepts. How the West was won, all caps. That's grossly incorrect. That's grossly incorrect. So we're going to spend this live going through this because that is a wild statement to put on the internet. And I know on Twitter, people can just put their hand on the Google and all of a sudden they have a legal degree by osmosis, but that is not how this works. So let's go through it. So first, we're going to start with contract and survivorship clauses, which I realized I skipped the whole agenda. So contract basics, we're going to do. Survivorship clauses, I realized that's something I don't think we've ever really talked about. Survivorship clauses, they usually, I would say it's not like a sexy topic, but it's an important topic. So we'll talk about that. I did notice in my perusal of the Twitter that a lot of people think that once you end a contract with somebody, then nothing stays, which is not correct and also interesting. So I figured we'd talk about that. We're going to do a little intellectual property 101, non-compete clauses. We're going to talk about morality clauses, which if you watch the Try Guys video we just did, we covered that. So a great use of that video will be in this video, a little 1 minute clip, and then some sip and discuss. All right, let me go ahead and get a wine. Thank you, boo. Okay, so let's get into contracts and survivorship clauses. Okay, so on the left, I'm realizing I need to do a better job when I use people's tweets. If they don't have a blue check, I'm just going to start blocking out their names just in case, they change their mind later and realize what they said was a little silly. Actually, can y'all see this? I should have made it a little bigger. Okay, so on the left, we have person A. I don't condone what he said, but here we go with the buts, child. If and buts were candy nuts and every day would be Christmas. But if he wanted to, he could produce the footwear and clothing on his dime and make all the money. It's not much different from leaving a record label and starting your own label. He could literally start a website and sell the stuff that way. Enter person B, the person with sense, who stated politely, copyright law is a thing. Enter back person A, who doubled down and kind of tried to be polite as well. You're right, but your response is incomplete. Without going into depth, start a whole new company. Honey, you cannot just say, I'm gonna start a whole new company, I'm gonna start over, and everything in my old contract is brand new. That's not how this works. That's not how this works at all. So survivorship clauses are clauses written into, I would say, almost every agreement, if not every good contract, which states Section 2, Section 3, Section 17, Section 8, indemnification, limitation of liability, intellectual property, payment terms, always. What are some other ones? Confidentiality will survive the termination of the contract. There are certain clauses that always survive, and they survive forever usually. Because what if you don't get paid? You want the payment terms to survive the fact that the person ended the contract, they haven't paid you. What if you have a contract with somebody and then they know all your personal business? Well, you want them to keep the confidentiality as long as that information is confidential. So for example, if you get an assistant, your assistant knows where you live, they know where you walk your dog, etc. You would likely write into your contract with your assistant, hey, you're cool and all. You like me. I like you. Maybe I'm an awful boss. Maybe you're going to hate me in 3 months. You fire me. You quit. Okay, you still know where I live. I don't want you telling anybody. So as long as I still live here and this is confidential information, please don't go around telling people that your old crazy boss lives in this building, etc. So an example of a survivorship clause is on the right. Let me make it a little bigger so y'all can see. The respective rights and obligations of the parties here under, including without limitations. So this is just including random examples. Section 8 through Section 11 hereof shall survive any termination of executive's employment to the extent necessary to the agreed preservation of such rights and obligations. So it will survive as long as it's necessary. In your employment agreement with your employer, there's always a survivorship clause. Always. They usually include non-disparagement. You can always negotiate. That's usually the last clause that lawyers will negotiate in a deal is a survivorship clause because everything else will move around. So when you're in the home stretch, it's like, okay, what do we want to agree that will survive the termination of this agreement? So no, you cannot just say, hey, you fired me. I made a new company. I did whatever I want to do. I don't have to abide by the fact that, for example, in this example, Adidas owns the IP. All right. Which brings us to copyright and trademark. I feel like today we're having very much a professor class, which also, even though it is the fall, I refuse to recognize the fall because it's warm in New York today and because the fall means the winter is coming and I detest the winter. So a little one-on-one basics, which most of y'all, if you've been following me for a while, you already know this. And in general, I think most people are comfortable and familiar with the concept of copyright. So copyright is the exclusive, keyword on exclusive, legal right to reproduce, publish, sell, or distribute the matter and form of something. And let me make myself smart so you can see the second part. So under Section 102 of the U.S. Copyright Act, which is codified as 17 USC 102 through 18, copyright protection exists in original works of authorship fixed in a tangible medium of expression from which they can be perceived, reproduced, or otherwise communicated either directly or with the aid of a machine or device. So in this example, the Yeezy sneaker themselves, the design is the copyright. It is fixed. They wrote it out. They sketched it. Artists helped with this, a whole design team. They sketch it out. They likely uploaded it to computer. They have it in a fixed medium. They then take that, maybe they do a 3D model, etc. So copyright's there. Now, specifically for the people on Twitter that for some reason were like, no, he owns it, even though Adidas said, we own all the designs. Stop asking these questions. This is the copyright right here. So let me make myself small where you can see this is from 2017 from the copyright catalog, which is public information if you'd like to look that up. So Adidas AG address. Oh Lord, this isn't French. I mean, this is in German. Sorry. Straße. It's in Deutschland. That is who owns this. Yeezy Boost 350 version 1. They own all of the designs. The next one, Yeezy Boost 350 version V2. They also own that. This copyright is from 2016. Copyright is interesting in that, say I do this live podcast, right? Or live podcast. I was talking to somebody earlier about podcasts and how that's a strange place over there. Say I do this live stream. We're doing the live stream. I'm telling you like, hey, we're going to walk through Adidas and Kanye's contract. It's getting fixed. These are my creative thoughts, my learned knowledge from being a practicing attorney for 6 years, from also being a recovering lawyer. Thank God for delivering me and for passing the bar on the first time. I've learned all these things. We're going to talk about them, etc. I've used my creative work. We fixed it in the medium, which is StreamYard via YouTube. It's gone uploaded to a platform. There is an inherent copyright. I could take it a step further. If I'm like, you know what? I feel like the people them are going to try me. I'm going to go to the United States Copyright Office. I'm going to file one of these things. So that way it's marked on this day, October 23rd at approximately 6:21 p.m. I did this thing. All these words are mine, 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 mine. You don't have to do that. Companies usually do that because it creates a paper trail. It's so much easier. But also, Kanye and Adidas had a joint venture partnership. So essentially, Kanye has his own company. Adidas is their own entity as well. And they said, hey, we're working together. So when we work together, yeah, the copyright is inherent, but who's going to own this? It is Adidas' very large design team, Kanye, and also his design team working together. And in their agreement, they clearly agreed, okay, Adidas, you got this. You're doing all this. I don't know who did more work. I don't know like their demarcation of design. Like did Kanye tell them like, hey, I think naming it Bone is provocative. It gets the people going, whatever. Picking the colors, setting the styles, who knows? Probably started, it's irrelevant. What's relevant is he agreed and he signed the contract that stated Adidas owns it. It is in the copyright here for anybody in confusion as to whether or not Adidas owns his designs. Yes, they do. Okay, now, which brings us to trademark. A trademark, which most people also know this, but I think a little primer sometimes is helpful. A trademark can be any word, phrase, symbol, design, or combination of these things that identifies your goods or services. It's how customers recognize you in the marketplace and distinguish you from competitors. For example, Wine and Chill is trademarked by me. Coca-Cola is one of the most famous trademarks, is one of the most protected trademarks, anything owned by Disney. Listen, how the fake characters in Times Square survive, I'm surprised. I guess Disney is like, you know what, I'm not going to argue with you all the time. Everything else, they're very litigious. So the trademark is the one thing that Kanye owns, but it's not the trademark to the shoe. It is the trademark to Yeezy. He trademarked Yeezy years ago. And here is the trademark to that. And this is the filing date the filing date for this is 2022, but this is the character mark. They have multiple filing dates for the word mark Yeezy itself. He has multiple of them. And so this, you go on the USPTO office website, and it always shows who owns the trademark. So this is specifically owned by Mascot Holdings Inc., and that is his holding company for all of his fashion lines, which I believe, if I remember correctly, he created and incorporated Mascot Holdings Inc. originally with College Dropout. The clothing that he was thinking of creating was going to be in line. That was the one that had the bear on it. So he's like, oh, it's a mascot. So he just kept that all these years. So while he owns the trademark and Adidas owns the designs, Adidas can sell the shoe and simply not use his name. So, which is the point of this very astute Twitter user, which since he has a blue check, I left his name up there. So from Nick DePaula, to me, in his opinion, this leaves the door open for re-releases, Adidas, and then he repeated that Adidas is the sole owner of all design rights to existing products, as well as previous and new colorways under the partnership. Brands will often re-release shoes, even if they are no longer in contract with the athlete artist. And then he listed out, I guess, what looks like the Yeezy shoes. I didn't know they had Uggs too. Honestly, a lot of these shoes are not my taste. I would never give that man any money ever since he said slavery was a choice, as we discussed the last time we let him raise our blood pressure. So first and foremost. However, people have decided to give him money for whatever reason. Adidas, because they own the copyright to the shoe themselves, can just say, this is the Adidas shoe. This is shoe 1, shoe 3, shoe 4. That's all. They own the full design. They can't market them anymore as Yeezys because he owns the trademark. So if you use somebody's trademark, A, they can sue you. It's not yours. Also, they stated in their statement, they're ceasing all payments, as in they are not going to pay him a licensing fee to use his trademark. They are cutting the loss. So maybe, and I think this is an interesting point, maybe they will re-release it. They already have product left on the shelf. It is still being sold by third-party retailers when I checked before this, which is going to be interesting. It's going to be very interesting. In terms of their joint venture, neither of them trademark Adidas Yeezy together. Neither of them did. So I think that's definitely in their agreement stating like, hey, if we part ways, we're done. We're done forever, which we're going to get into the morality clause a little bit later. All right, on to non-compete clauses. And a sip for me. 1 second. And we're going to the other hellscape on the internet, which is Shade Rip. All right. So, honestly, the first sneakers that he made, I was like, oh, these are cute, but I don't want to give him any money. So now that he won't get any money, but in my opinion, Adidas took too long to release him from this, and I don't appreciate that. So probably never going to have a pair, which is fine. Now, because again, people have, this one I would say is just a lack of good reading. So let's get into this one, which I should have made this a little bigger, sorry. So on the left, you have Kanye posted a text from one of his attorneys at Quinn Emanuel. Quinn Emanuel is one of the most prominent big law firms. They're very prestigious. They do great work. So his lawyer texted him, as to Adidas, you can start to make new design for footwear, apparel, and accessories immediately. As to Gap, the non-compete expires December 15th, 2022. You own the Yeezy name and all trademarks associated with Yeezy. So then Kanye made some very random ass caption child, which I'm not going to repeat. To which a blue check wrote, and quote, Quinn Emanuel is a law firm devoted solely to business litigation arbitration, which he took from their website. So kudos to him for being accurate there. And then it just went left. Basically, what he's saying is he owns his shit from Adidas, and on December 15th, he will own his shit from Gap. Pay attention. That's not what that says, boo. That is not what that says. A non-compete agreement, a non-compete clause in your contract states for a set period of time while you are in partnership, while you are in contract, while you are in employment with X person, you cannot do the thing we hired you to do. So for example, if you work, tech companies are notorious for enforcing their non-competes. If you are a salesperson and you work for a fintech company, so you know everything about this product is new, it's cutting edge, it's doing all these things, there is likely a non-compete agreement that says, yeah, you could leave, but you can't work at another fintech company for 6 months, 1 year. Non-competes are almost always in force. They're usually as long as you stay within a region and a reasonable amount of time. Less than a year is a reasonable amount of time. 2 years, the judge is like, you're kind of pushing it. What are you doing over there? It will get enforced. A non-compete, when it's done, simply says you can go do the thing that we were in a contractual relationship that you are very good at doing. So the salesperson, after your 6 months is up, you can go work at all the fintech companies you want, go sell all the things, do whatever you want, rack up all your money and terrorize all of your coworkers, because salespeople in tech are unpleasant. If you've worked in tech, you know, unfortunately. You can do that. A non-compete doesn't erase the rest of the contract. There are survivorship clauses. There's ownership. Non-compete has nothing to do with the IP. Adidas still owns the IP. Once the non-compete is over, he can make new designs. He can do new things. He cannot go and say, yeah, those Bone Yeezy, what are they, 350? I'm not very familiar with the shoes. Yeezy Boost 350s. He can't go and say, yeah, I'm going to make Yeezy Boost 350s with Skechers. It's not going to happen. That's not how that works. All right, which we haven't checked the comments. So now let me check the comments really quick so I can drink wine. Justin, it's so strange that people don't understand the basics of a partnership. Listen, that's why I was like, at first I was like, I don't want to talk about Kanye. I'm tired of it. But it does seem a lot of people without being, there's one group of people that is like, well, it doesn't matter if he goes and turns into this awful person, which he has and has been for a decade. I'm going to support him. And then I've noticed on Twitter, there's a section of people that genuinely just don't understand how contracts work. So I figured that this could be a helpful video for those people. If you, again, are still enamored with that man, I can't help you. Can't help you whatsoever. All right. Which the last person, which I'm just going to repeat the name because why is that the name and it's verified? Squirm Jesus. What? Okay. Got out of his deals without having to pay lawyers and going to court to own 100% again. Genius. Sir, ma'am, person, human being. No, that's incorrect. He definitely paid his lawyers at Quinn Emanuel. He's definitely paying his lawyers at Pryor Cashman, who are filing his trademark. He doesn't own anything in terms of the actual copyright to the design. He owns the trademark to Yeezy. That's what he owns. That and that alone. All right. So I figured it might be helpful that we look at a non-compete clause. We won't read the whole thing. It's very dense, of course. I pulled this from one of my employment contracts from like way back in the day. So covenant not to compete. So that way you're familiar with it. And that way, as an employee, you know what exactly is in there. Because if you are in a very specialized field, say you are, I don't know, I'm trying to think like what's something very hard, some computer wizard that only works on AI for medical devices, and there are only 3 companies, a non-compete will greatly affect your life if you decide to leave that job. So it's definitely important to negotiate your non-compete. As a lawyer, usually our non-competes are very much, we retain the knowledge. It's our legal expertise that has nothing to do with the business that we came into the business having. So we usually don't have very strict non-competes. So this one, covenant not to compete, I agree that during the course of my employment and for a period of 12 months immediately following the termination of my relationship with the company, whether I resign voluntarily or am terminated by the company involuntarily, I will not, without prior written consent of the company, whether paid or not, serve as a partner, principal, blah, 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 directly or indirectly, own, purchase, organize, or take preparatory steps to organize, build, design, finance. You see, it covers everything, anything within the covered business. And then they will then go on to define our covered business is as broad as they'd like. So if you are negotiating your non-compete with your employer, you want to say, listen, oh, see, like the new mic. Listen, your covered business is not, where am I? Hold on. Your covered business is not this huge thing. Your covered business is specifically, you make AI chips. This is not real. AI is machine learning. Let me say something sensible for people like, you don't know what that is. I know, saying nonsensical things. You make specific computer chips for medical devices. You do not do machine learning, AI, anything to do with any type of device that touches the human body. So you want to make sure they limit what their covered business is and also limit the amount of time. If you're like, you know what, it might take me a while to find a job that I like, Tell them like a year is too long. Can't starve. Let's do 6 months. All right. Okay, on to the catch-all of morality clauses. Now this, I can finally drink my wine because I'm just going to play an old version of me from earlier this week where we talked about morality clause in the Try Guys video. So if you haven't watched a Try Guys video, it's a little, Caucasian mess. It's interesting if y'all want to watch that. All right. Morality clauses came about in the United States in 1921 at the detriment of a one Roscoe Arbuckle. Roscoe Arbuckle was a very famous actor in silent films. Unfortunately for him, he was accused of manslaughter after 2 deadlocked juries. In the 3rd jury, he was finally acquitted, even though all along there wasn't much evidence supporting that he actually did anything wrong. However, fueled by the media and the public surrounding his case, many theaters refused to play his movies. Ultimately, the studio lost millions of dollars. So for that to never happen again, they decided to insert morality clauses. 11 days after his arrest, on the ground that he was locked in a San Francisco jail and unable to report to work. The next day, Universal, who's still around, wrote a morality clause into its contracts mandating non-payment to performers who forfeit the respect of the public, and other studios followed. Morality clauses are essentially everywhere in entertainment as well as sports. I would say sports is a subsection of entertainment. Morality clause is a contractual provision in a talent contract, and a talent contract is an employment contract. A talent contract would state, if you do anything that causes we, the studio, the brand, the corporation, to look bad, you do anything to make yourself look bad, you engage in what we solely deem unilaterally to be reprehensible behavior, we're firing you, we're breaking our contract. It is a get out of this contract free for a lot of brands to use, and we see it being enforced year after year. The courts uphold that morality clauses are fully legal. All right. So that is how morality clauses work. Clearly, it's very easy to see as to how Mr. Kanye West obliterated his morality clause, honestly, multiple times. I would say the reasoning that Adidas finally was like, okay, this is the last straw, probably because their stock was plummeting, most likely. And to end on, Twitter is simply a delusional place. I figured we'd have some tweets. This person, I see nobody actually listened to the interview. He does not need Adidas. They need him. He has the manufacturers now. I find that interesting because I have a headline to show right after that. So again, I will say I do like that at least on Twitter, people were trying to argue with the stands in such a very like, you know what? Y'all got to let this go. No one needs him. It was a good ride. It's over. And specifically what then happened is, I'm going to laugh when Kanye picks up another manufacturer and rolls full steam ahead while not having to give up a dime to Adidas. He then decided unannounced. My pet peeve in life is people that show up to your house unannounced. Everyone has had that one friend where you're like, this is not Tia and Tamara and Roger. You cannot just pop up on me like this. This is wild. Skechers executive escort Kanye West out of the building, company says. And specifically, they made a statement which stated that he was unauthorized and showed up to their corporate office. Just popped in, just decided, I'm just going to mosey myself over here to Skechers, the company best known for very comfortable and very cute children's light-up shoes. Okay, I just want to know that people's fave is down bad and sad. And I'm not particularly mad about that. Specifically, Skechers said, the comfort technology company stated Kanye West, also referred to as Ye, arrived unannounced and without invitation at one of Skechers' corporate offices in Los Angeles. I can't imagine if I still worked in corporate and I looked out the window and was like, is that? Why? What is he doing? Considering Kanye was engaged in unauthorized filming, he then filmed himself. Child, I guess he thinks he's an influencer. Maybe he was making a vlog. 2 Skechers executives escorted him and his party from the building after a brief conversation. Skechers is not considering and has no intention of working with West. We condemn his recent abusive remarks and do not tolerate anti-Semitism or any other form of hate speech. The company would like to again stress that West showed up unannounced and uninvited to Skechers' corporate office. They would like to stress this because this is stressing them the hell out. I know the entire legal department was like, who invited this man? What is going on? And the poor person in PR who had to figure out, how do I stress enough that nobody invited him here. But yes, people think that he's just going to get a manufacturer when he does not own the designs and all he owns is the trademark to Yeezy. It is not that easy to mass manufacture sneakers, and if it was, more people would do it. But again, what do we know? The people on Twitter, they have all of the knowledge in their brain. So on that point, let's get into some wine time. Alita, we promise we don't know him. I would be mortified. I would be personally mortified. Shanley, TMZ needs to release the footage. That would be hilarious. I think that is what everyone needs, a good chuckle and reprieve after the weeks of him terrorizing all of us. Mess. All right, so let's get into some comments. If you're just tuning in, you can go ahead and scroll to the beginning because all you're going to see is hair and forehead and some comments. All right. Which did I forget to put? Oh, I forgot one. One Twitter user, which was hilarious. They had a funny joke. I forgot what they said exactly. It was something simply along the lines of, I can't wait to buy Yeezy Stormtroopers at the Hobby Lobby. And that was a good one. Tenebraification. Most people don't understand how local, state, federal governmental services work. I'm not surprised they don't understand business partnerships and the like. Yeah. These are the things I think we should spend more time on in school. I think so. And I would also stress to people that while the law is daunting, there are a lot of really good resources out there, YouTube being one, to just educate yourselves on the basics of contracts, because you don't need to go to law school to just simply understand a contract. Going on Twitter loud and wrong and claiming you know and showing the whole of your ass is a little bit of a wild choice to do. It's a little bit of a wild choice to do. All right. Let me go ahead and go through the comments. Okay, I guess we'll go midway. Okay, cool. I'm going to start doing that. So this top is from, which is fun because I tucked it in because that's how they had in the pictures, but it's actually a collar too. So it's like a whole button up. Is from, oh man, it was just in my brain. Hold on. It's the Black owned like thrift up place where everything is thrifted, but then she reworks them. Y'all have probably seen her. She has like really great clothes. I'll remember in 5 seconds and I'll put it on here. Actually, I think it is on my Instagram. I was like, I've been trying to like put things on my Instagram. It's on my Instagram. So let me see. This is from Random and Chic. That's where this top is from. I don't remember where these are from. It's probably in some video. Thank you, boo. All right. Exactly this. He's just a problematic. I can't even give energy. The most energy I can give is to look into the legal parts of his foolishness now. That is the most energy. Cause I can't give him any other energy anymore. It's trifling. Thank you, Tia. If you haven't already, go ahead and like and subscribe. Oh, also, before I forget, it's 6:41. We will start on time. So Patreon, we have hit 250 patrons. So thank you all. I appreciate y'all and all of your support. And I think I said it last week, but we are going to do our all Patreon live to celebrate tonight at 7. So if you want to join Patreon, let me go ahead and drop that link. I will give y'all the link to the exact, if you want to join that live. I'm not sure what we're going to talk about yet. I think we're just going to have a free-for-all. So that'll be fun. Let me see if this is it. Hold on. Yeah. Okay. Here you go. So I'll put that here. So Patreon, usually the lives are for the $10 tier, but it's going to be the $2, the $5, 10, 20, all of them for this. So just wanted to say thank you to all of you. So there's that. I wonder what their divorce proceeding is going to look like. I think that would actually be a fascinating video to do and to see, just because they have so many holdings and because I reckon there's levels of debt there And it's just a bit interesting in terms of how they're going to divvy everything up. So, yeah. Exactly this. Nezuko. Legal degrees by osmosis are triggering for all of us recovering from the profession. It's as deep as the amount of money you pay for the degree. Yes, child. Which we're gonna do my student loan video on Sunday. I'm gonna try and make, yeah, because the month is ending and it's supposed to be one a month. And we're gonna talk about the student loan cancellation and making sure everyone fill out your form if you qualify. So I don't qualify. I've come to terms with it. I'm fine with it until they email me telling me to apply, and I'm like, y'all know good and well that you're screwing me, and I'm getting not a red cent. So stop sending me this email. But yeah, so we're gonna go through that. So that way, I think now it's 21 million people have already applied for student loan cancellation, which is great. So if you have forgot, make sure you apply. It's really easy, the application. All right. I'm just scrolling through the comments. It's exactly this. Completely agree, Kiki. Completely agree. Which is why I'm like, I'm refused to give that man energy. But he's a great case study, at least his contracts are, in terms of learning about things. So there's that. All right. And that's what he's never going to learn. And that's why people who play respectability politics are never going to learn. You don't have the complexion for protection to do these things and walk in that direction. It's not working for you, boo. It's not going to work. To Kiki's point, who does he think he is walking up in Skechers? Elon Musk? He doesn't have the sort of skin privilege, no matter how rich he is. Exactly. Exactly, child. Yes, that Hobby Lobby, Sharon. Have I thought about teaching? I mean, not in a legal sense, but I was for 3 years in college a swim teacher, a swim instructor. So I know I have the patience for teaching. I like to teach. That's like a different type of teaching. Teaching a child how to swim, wild experience. Kids are funny. Especially a class of kids, 6 kids at one time in a pool. You gotta pay good attention. But yeah, maybe. I'm not opposed to the idea of like teaching a legal class. I would say this is mostly what I blame it on too, Candace. I honestly blame educational disparities for folk not understanding how contracts and partnerships work. I blame that, except when the people have everything at their disposal and decide not to read, which we talked about last time we talked about Kanye, how he's very proud to tell people he doesn't read. And I'm like, you are a alleged faux billionaire. Why? You could have someone read a book to you. So people that dig in to be loud and wrong for no reason, sad. Makes me sad. No, Wu Chile. I remember when that happened. That was my favorite. Yes, Millie, that's correct. So he can market new designs under the Easy title. Yes, he can, depending on his non-compete, which the Gap non-compete was in December of this year. It doesn't seem, Adidas didn't mention his non-compete. And in the screenshot that he posted from his lawyer that he clearly wasn't supposed to post because he then deleted it, they didn't mention Adidas non-compete. So yeah, he technically could. But the thing is, who is going to back him? Because you have that the infrastructure for production for a shoe company. You can't just be like, oh yeah, I'm just going to do this thing. So as Skechers showed him the door, I don't see anybody with any sense being like, oh yeah, let's take on this fool. All right. Thank you, Empress Gigi. I appreciate you. The Dance Valley. What's the difference between trademark and IP? So intellectual property is the big umbrella. So what is the word right now? The category of law. So like contract law, maritime law, which is anything to do with like oceans, waterways, tax law, property law, IP, intellectual property law. And then trademark is just a subsection of IP. So under IP, you get trademark, copyright, and patent. So patent are the processes. So anything to do with like engineering, whether that be digital or manufacturing. Russell Simmons. Child, Lord have mercy. Exactly this. Exactly this. All right. Well, on that note, I think we've gotten through everything. I was going to ask y'all, are there any other topics you guys want to cover? Well, not today's Thursday, next week. I'm gonna be realistic since we'll do the student loan video. Let me know. I did, and I started doing the initial research of the Darrell Brooks case, which he was found guilty on all charges, as he should be. And we rarely ever cover crim because crim raises my blood pressure, to be honest. But I do think his trying to figure out how to say this because it's just objectively wild. His fake defense of sovereign citizens, which is not a real defense. There's actually a rise of people buying into that very no-tep philosophy. So I was thinking maybe we would do a video on that. So let me know if y'all want to do that. We can cover that because I think it's fascinating for obviously all the wrong reasons, but a good way to kind of look how in the Black community, how we have fringe communities that because people have not received, in my opinion, like proper equity in our legal system, they have ran left, all the way left to a place that makes no sense. That makes no sense. Listen, I really think, and this maybe is like a hot take, but I really think that people should not be allowed to represent themselves. Client that has a lawyer that has himself for a client is a fool. Nothing good is coming out of it. Nothing good ever comes out of it. It's just like the other man that unfortunately harmed, I believe it was his wife and his children, also represented himself like a couple months ago. And someone had sent it to me and I was like, crim, I can't do crim. But I do think it's very interesting. Exactly this. I think there's a lot of intersectionality with libertarians and just all out like political foolishness. So I do think it could be interesting to cover. So maybe we do that. Yeah, I think if we do that, Brittany, if we do that topic, we're definitely need mods in the chat. The uncle, they will be very angry. They will be very angry. I think maybe we'll do that one in an edited video because I think it's probably too much for a chat to cover that. People will lose their mind. People will lose their mind. Honestly, while I can't stand him, Kanye, and I've said this before and I said it in that video, he does hold a special place in this channel because that is the video reviewing his contracts that a lot of you found the channel from. So thank you, sir. The one time he decided to help a Black woman, I suppose. I feel like Kanye's content holds a special place on this channel. I discovered you through that video on Kanye's Def Jam contracts. You guys should read his contracts. He still didn't learn. He still has not read them, which is wild. Or his attorneys have still decided not to actually advocate for him. Either or. But yes. Antonio S. They don't allow doctors to diagnose themselves. Exactly. So I think that could be a good video that would touch on a lot of topics. So maybe we'll do like more so that would probably be more of like a commentary video, even though there are some legal aspects. Of course, he was representing himself, but more so focusing on the rise of sovereign citizens. Because if you ever meet somebody in person that really believes that in their spirit, is fascinating, frightening, and also very fascinating. All right. This is part of it because the public defenders are extremely underpaid, extremely overworked. So the public defenders, you know that, okay, if I get this person, they might not even know my name. They might try and they might still lose because they're working 70 hours a week. They make 40 grand, $40,000 in New York. They make no money. They're basically in poverty. They are in poverty as well. So the system is designed to disenfranchise poor people. So it's like a huge thing. So with that, I always like my idealism would be, oh, if you paid public defenders more people could afford to be a public defender. If you look at who's usually public defenders, is people who either their parents have worked in public service, so they are very much dedicated to it, or there are actually a lot of, their scruples, it depends, unscrupulous, semi-rich people that go into public service so that way they can have a political career because they can afford it. If you can't afford to take that pay, it causes an issue, which the person that suffers at the end of the day is the person that actually needs help and needs good legal counsel. So I think it'll be interesting. Very interesting. Oh yeah, they're not paying them. I have a few friends that are PDs in New York when we graduated. People usually last a year at most. The people that last more than that is because they genuinely are trying, and the level of mental anguish those people go through is not right. It's not right for people who are like, I'm trying to do everything, but then they have their caseload is so high. So high. So wild. Scrooge McDuck. I'm a little bit behind, but who the hell was Kanye's lawyer advising on this contract? Questions that need answers. Somebody that collected their billable hours. Somebody that collected their billable hours. So there's that. Hey, Aunt Judy. Miss Opinion. Question. Are you aware of Badass Public Defender on YouTube? She is black. Okay. I was like, and black. And I was like, oh, the B is there. No, I'm not. I'm going to go look her up. I'm going to look her up. Because I know a lot of like whip smart, well-meaning, doing everything they can. And the system is not designed. The system is designed to burn those people to the ground, to burn them completely out. It's wild. I have the utmost respect for public defenders that stick it out. Because I couldn't do it. I've said it a million times. I'm like, I couldn't do it. All right. Well, on that note, it's funny, y'all have given me some requests for some shows, so we might. I think I might invest some money in an editor, aka smaller, less money given to my student loans. Because at this point, I paid off $150,000. For those of you that are new and that don't know, this channel started as a student loan vent diary of, hey, I owe all this money, $75,000 just in interest for trying to get education. So I paid off so much money, 150 grand, and I still owe 168-ish. I haven't updated on Instagram in forever because I'm over it. I'm tired of it. So I've come to a point where I'm giving them less money in the payments, even though they're in deferment, so we don't have to pay anyway. And I'm going to invest in the channel. So one of the things that I'm hoping to do in the next couple months is get an editor so we can get more content out. So yeah. So that's my goal. So if you know any good editors, feel free to email me. My email is wineandchillstephanie@gmail.com. So I'm looking for an editor. Hopefully, I've interviewed with some people that other people have recommended me, but I really would like a black editor. So help a fellow black creative. So if you know anybody, I know there's plenty of people. I just have to find one. So let me know, child. Let me know. Well, on that note, we had a quick live. Oh, well, I'm going to attempt to be on time for Patreon. So if you're on Patreon, we're going to have a little celebration. Bring your wine. I will see Patreon in 4 minutes at 7. We're on time. I'm on time-ish. And I will see y'all later in the week. All right. Bye.